Great. So again, I'd like to welcome everyone to this Wisconsin Facets webinar on school discipline. Today we will be discussing manifestation determinations and expulsions. Our presenter today is Marge Resan. Marge is a school administration consultant on the special education team at the Wisconsin Department of Public Instruction, better known as DPI. She has been working at the department since 2008. Her work focuses on compliance issues, monitoring, and idea complaint investigation. Marge was a special education teacher in the Madison Metropolitan School District for several years, where she taught many students with a wide range of abilities in the classroom, community, and in vocational settings. Marge holds a law degree from the University of Wisconsin and has worked as an attorney in the areas of disability and elder law. With that, I will now turn things over to Marge.
Great, thanks, Courtney. Well, I'm glad everybody's here today. This is a topic that is a really, really complicated and tough one. And what I think we tend to find is that in many cases, people don't deal with it very often. So when it comes up, it can be a real tricky one for families and for schools alike. So I'm so glad that you're all here to take some time to do some learning about it with me today. And as Courtney had mentioned, I'm very happy to take questions. I will answer them at the end. And if you have specific questions, I want you to feel free to get in touch with me. We answer questions about these topics on a pretty regular basis, so please know that we're here as a resource for you. So let's see here. Okay, there we go. So here's what we will discuss. Today we're going to talk about what a manifestation determination, or an MD, and I'll probably call it both a manifestation determination and say MD interchangeably through this presentation. We're going to talk about what it is. We're going to talk about when they're required. And interestingly, they are not required maybe as often as they occur in a lot of Wisconsin schools. We're going to talk about what a disciplinary change of placement is. And that becomes really important because that's the trigger for when a manifestation determination is actually required. We're also going to talk about what happens after a manifestation determination has happened and what the next steps procedurally are for teams as they move forward. So a manifestation determination, really all it is a process that's used and required under federal special education law to determine whether a behavior that resulted in a disciplinary change of placement is a result of a student's disability. So really that's the purpose of it. It's to determine whether the behavior that a student is in the process of disciplinary action, receiving disciplinary action because of that behavior, whether that behavior is a result of the student's disability. And really the reason it's done, because if the behavior is a result of the student's disability, the student's placement cannot be changed without the parent's agreement. And even if the behavior is not a result of the student's disability, it's important for the IEP team to take a look at some at things and consider how to meet that student's needs if the behaviors are maybe different or new or changing. The big thing is that a manifestation determination is required only when a disciplinary change of placement is being considered. So that's the only time. So the question that follows naturally next then is, what is a disciplinary change of placement? The law defines two different scenarios that qualify as a disciplinary change of placement. So a disciplinary change of placement occurs when a removal, so a series of suspensions, is for more than 10 consecutive days, so 10 days, school days in a row. Under Wisconsin law, this can only happen if a student is being considered for expulsion. So there shouldn't be any 10-day consecutive removals from school without other procedures around expulsion also being commenced. So that's one disciplinary change of placement. And then the other disciplinary change of placement scenario is when a series of removals that are more than 10 cumulative days, so total days, not necessarily consecutive, within a school year constitute a pattern. And that determination of what a pattern is also described in the law. So a pattern of removals that occurs when a student has been removed from school, from their current placement, for more than 10 total school days within a single school year, and the student's behavior is substantially similar to previous incidents. And the way that that's determined under the law is that's determined by school staff at the time of the behavior. We'll talk a bit more about that in a bit. But what school staff must consider is other additional factors such as the length of each removal, the total amount of time a student's been removed, and the proximity of the removals to one another. Those are things that must be considered. Who decides this? As I mentioned before, this is made on a case-by-case basis with the school district. So what happens is at the time of any removal, we'll say a suspension that is happening after a student has reached that 10 days of total removal, the school staff, and it's generally an administrator, often a principal, we really highly recommend that that principal consult with the student's special education teacher, who will have knowledge about the student's disability and how that shows itself in that particular student. But those folks make the determination on a case-by-case basis at the time of the removal. That can be really tricky, and it can be really, again, oftentimes when disciplinary circumstances are happening, you know, there's a lot going on. It can be a very busy, kind of confusing, and there can be a lot of emotion. And at any rate, it's important to know, though, the decision about whether a series of removal is a pattern is made by the school district, not the IEP team, but the school district. We just really want to make sure that the folks that make this decision have good information about the student and the student's disability-related needs at the time that determination is made. So this slide talks about when a school district may expel a student. And in kind of the statutes, we talk a lot about things, whether they're a may or a must or a shall. May means that this is allowable but not required. So you may see school districts exercise some amount of discretion in making these decisions. But under Wisconsin law, a student may be expelled from school if that student repeatedly refuses or neglects to obey school rules, threatens to destroy school property by expulsion, and certainly we can understand that one, engages in conduct at school or at school-sponsored activities, endangering the property, health, or safety of others, engages in conduct not at school that endangers the property, health, and safety of others. That can get tricky sometimes, and again, there's a whole bunch of law around what that means and when those things can happen that really goes beyond the scope of what I will talk about today. When a student engages in conduct that endangers a person or property, including making a threat to the health, safety, or property of another. We get a lot of discussion about threats and what they mean and where they happen, and so lots of that kind of thing. When a student is 16 years old or older, if the student repeatedly engages in conduct at school that disrupts the ability of school authorities to maintain order. Boy, that's language that came straight out of the statutes if I've ever heard it. But in those cases, a district may choose to move toward expulsion with a student. There are a few times under the federal law, basically, and then state law that really what the law basically says is that under these circumstances, a school district must move toward considering expulsion of a student. And that involves a student possessing firearms on school property. Now, they say must, but then it also says that it can be modified on a case-by-case basis. So again, even in a circumstance here where there's a must, there is room for school districts to offer some level of discretion in this. But certainly possession of a firearm on school property is a very serious situation, and schools they need to be dealing with that. Here's a question that we get from time to time. The question is, can students with disabilities be expelled from school? The answer to that question is yes, they can. Students with disabilities can be expelled. However, when a student with a disability is expelled, the school district must provide that student educational services determined by the student's IEP team to enable the student to continue to participate in the general ed curriculum, and that can be in a different setting, certainly, but they should be allowed to continue to make progress and participate in the general ed curriculum, and also make progress toward meeting that student's IEP goals. So whatever individualized goals that result from the child's unique circumstances. The district is required to provide those services. They need to be designed to provide a free, appropriate public education, or FAPE. That FAPE guarantee still applies when students are expelled. We get questions from time to time about the services that students receive when they're under an expulsion, and again, it's really important to remember that it means that the student should be receiving FAPE. One of my little lines you'll hear me say from time to time is that there's no such thing as FAPE light. You don't get FAPE light when you're expelled. You still are entitled to FAPE if you're a student with a disability. So that can be a little tricky sometimes. So now let's talk more about the manifestation determination process. We've talked about when they're required. We've talked about when a student may be expelled. So now we're back to, let's remember that in the circumstances when a student's conduct results in the district making a decision to make a disciplinary change of placement. Those disciplinary changes of placement are 10 days of consecutive removal or 10 days of cumulative removal when there's a pattern. That's the 2 times this is required. A manifestation determination must be made within 10 days of the date of the decision to make the change of placement. So the date of the decision is the date the district decides to remove the student for more than 10 consecutive days. That's often the date of the notice of expulsion. Something that I have kind of come to understand better is that it's not uncommon school district practice to issue a 5-day suspension initially when a behavior occurs, and then use those 5 days of removal to sort of investigate and make sure that they're going to proceed with the expulsion. And then on day 4 or 5, the actual required expulsion notice will be issued at that point. So it's not, the notice of expulsion required by statute has some real specific things, like it has to provide the time of the expulsion hearing, things like that. It's very specific. That doesn't necessarily happen the same day the student is initially suspended. That often happens 5 school days into the suspension or sometime within that range. So either the date the district decides to remove the student or the day the district determines a pattern of disciplinary removals is a change in placement. Now, as we talked about earlier, the district staff, and again, we recommend that's usually an administrator and one of the student special education teachers, makes that decision about whether a series of removals is a pattern at the time of the removal. So that if at that moment the staff determine that this is a pattern, that starts the clock ticking toward the 10 school days to make the manifestation determination. Who is responsible for conducting the manifestation determination? Well, under federal law, basically what they say is that a representative of the local education agency, so an LEA representative, usually an administrator of some sort, the student's parent, and other, and this is what quotes from the law, relevant members of the student's IEP team. So it doesn't necessarily have to be the whole IEP team to make the manifestation determination. However, what we found is that in Wisconsin, it is quite common practice for the whole IEP team to be present to conduct the manifestation determination. So again, I think that's just a peculiarity of the way we do things in Wisconsin. Other states, it's not necessarily that way, but in Wisconsin, it happens that way quite often. And I think probably part of the reason for that is that there are often discussions about placement that happen around the time of a manifestation determination. And in order to make a change of placement, it's necessary to have the IEP team, the entire IEP team, be present. Or I guess to say it's required to have a legally constituted IEP team be present. When is behavior considered to be a manifestation of the student's disability? There's two things to consider. First of all, if the conduct in question was caused by or had a direct and substantial relationship to the student's disability, it must be considered a manifestation of the student's disability. So in those circumstances, there's going to be a lot of discussion about what the nature of the behavior was, what the nature of the student's disability is. That can look so many different ways, but that's the discussion that the team is wrestling with. Either was the behavior caused by the disability, or was there a direct and substantial relationship? That's thing one. The other possibility for when behavior is a manifestation is if the conduct in question was a direct result of the student's IEP not being implemented. So in circumstances where, say, for example, a student has a behavior intervention plan designed to help support them so behaviors don't occur, if that behavior intervention plan was part of the IEP and was not being implemented, potentially that is right there enough to say this was a manifestation of the student's disability. So these are the two kind of ways that can happen. One of the things that I find really important to stress here is that when we say disability in this context, we are not talking about the student's impairment area. What I mean by that is we are not talking about whether the student is identified under a certain category under a special education law. So it doesn't matter if we're talking about autism, or if we're talking about a specific learning disability, or if we're talking about another health impairment. Those labels are used in IDEA for eligibility purposes, but when we're talking about disability for this purpose, we mean how the student's unique disability-related needs come out in the student. So even if a student, say, for example, is not identified under, say, the emotional behavioral disability category, if they have some components of their disability that involve behavior, even if they're not identified under that area, this IEP team still really needs to consider that when making the manifestation determination. The big takeaway here is that disability does not equal label or impairment area when they're having this discussion. It has to be a really true individualized discussion based on that student's disability-related needs and the way that disability manifests itself in that student. So what does the team need to do to make this determination? So the team really should be engaging in a detailed and thorough review of relevant information in the student's file. Certainly the student's IEP is important to look at. Current teacher observations, what things have staff been seeing in school. Parents are very much welcome and should provide relevant information that whatever is provided needs to be considered by the team. Often this includes information that wouldn't maybe be directly in the student's school records, like medical diagnoses or medications. Oftentimes we see changes in students' behavior for any number of reasons, medical reasons, etc. That information is information that certainly should be brought to the team if parents are comfortable doing so, and it really needs to be truly considered by the team in making the determination. What happens if the team determines that the behavior is a manifestation of the student's disability? So again, this happens when the team has determined that the behavior was caused by or had a direct and substantial relationship to the student's disability, or the behavior was a direct result of the student's IEP not being implemented. If the team determines that the behavior is a manifestation, the IEP team must conduct a functional behavioral assessment around the behavior of concern, unless one's already been conducted, and create or modify the student's behavior intervention plan, BIP, often called, or BIP, to address the student's needs. So if the student hasn't had, if it's a new behavior, if the student hasn't had a functional behavioral assessment around that behavior, it's important that the team take the time to do a good FBA around the behavior that is in question. FBA is a whole topic for another day that could go, that could be a whole probably weekend presentation of it in and of itself, but there is information on our website about what an FBA is and what that process should look like. And it's important to, address the student's behavior to make sure that we're providing the services we need to make sure the behavior doesn't recur. Again, if the behavior is a manifestation, the district must return the student to the previous placement. So if the student was removed from school, that student must be returned to school. If they were removed from attendance at, picture regular high school attendance, and they've been suspended off campus, they need to be returned to that setting unless the parent agrees to a change of placement, and that happens from time to time. That parents will say, yeah, given what's happening with my child, maybe they do need something different right now. But if the behavior is a manifestation determination, it's really the one time that parents need to agree to that change of placement. It's not a time that the district can unilaterally make a change of placement. That is, unless the behavior involves weapons, drugs, or serious bodily injury, and those are things that all have definitions in federal law. If the behavior involves those things, then the school district can unilaterally place the student in an IAES, or Interim Alternative Educational Setting, for 45 days. It's also possible, I don't think it happens very often, but it's also possible that if a district is concerned that a student's behavior could really be likely to lead to someone being injured or something like that, they can also go to a court to get a court order around changing placement. I don't think that happens very often. I think probably more often the 45-day IAES might get invoked if one of those things is involved. So a little more about one of these interim alternative educational settings. So even if the behavior is a manifestation, if the behavior involves these things, the district can unilaterally remove the student to an IAES for up to 45 school days if the student, while at school, on school premises, or at a school function, carried or possessed a weapon. There are definitions of what a weapon is and what a weapon isn't for this purpose. We often see discussions about, so if a student, say, had a pocket knife at school or some other kind of a blade, you'll see measurements of the blade in the file, because certain blades are long enough to be considered a weapon, certain blades are not. So there are definitions to these things. If the student has been selling or soliciting the sale of a controlled substance, boy, easy for me to say. So again, that's when the behavior involves either the selling or solicitation of drugs, or inflicts serious bodily injury upon another person. Now, serious bodily injury is a very, very high standard under the law that applies to this. Sometimes, students, their behavior will result in injury to staff or to another student, and that's not fun for anybody. That's a difficult position for everybody to be in. But for a student to be removed unilaterally from school when it's a manifestation of their disability, the injury must be very, very serious. It talks about a substantial risk of death. Again, it's a very, very high bar. It is extremely rare that the type of injuries that we hear about that have led to disciplinary removals involve serious bodily injury. It's very rare. So it's a very, very high bar, and it's important to just keep that in mind. But if that is the case, districts can place the student without the parent agreeing in the interim alternative educational placement. So districts, under certain circumstances, can request extensions to IAES placements, but when the request has to go to a due process hearing officer, so it's not something they can just do unilaterally after that first 45 days expires. And again, there's a lot of nuance and detail that's involved in all of that. So let's go back to the determination. What happens if the team determines the behavior is not a manifestation of the student's disability? So that would mean that the behavior was not directly caused by or had a substantial relationship to the student's disability, or if the behavior was not caused by the IEP not being implemented. Under those circumstances, students can be disciplined in the same way that would apply to any student under similar circumstances. And this does include expulsion. Students with disabilities can be expelled from school. However, and this is a big however, the student has to continue to receive educational services designed to provide that student FAPE. No such thing as FAPE Light. The IEP team has to, at that point, determine the services, what they will be, and the settings in which the services will be provided. It's not unusual for that to not look exactly like a full school day or something like that, but it really is important to remember that the services do need to be designed to provide the student FAPE if they're for services that are provided to a student during a period of expulsion. So that's pretty much in a nutshell what happens. And again, there's a lot of particular circumstances and different things that can happen that can result in change in different scenarios under all of these circumstances. So it's again, it's a lot of nuance. There's a lot of when a situation comes up, in many cases, it's not something districts are accustomed to dealing with, and certainly for parents, it is definitely not something that most parents are accustomed to dealing with. So it's a complicated situation, and it can be full of lots of difficulty. We have a few resources that are out there that are available on our website that are very helpful in these circumstances. And actually, the way I've got them listed on here, I'm going to talk about them sort of in reverse. The bottom dot point here, the answer to frequently asked school discipline questions, is a great resource that talks about how discipline applies to all students. And we have to always remember that our students with disabilities are students first, right? So the way laws that apply to all students do apply to our students with disabilities. It's just that, in addition, the students with disabilities have protections under disciplinary provisions of the law. So that is a great resource for general questions about school discipline. Then kind of going up to the next dot point, this one, Information Bulletin 0602, talks about the legal requirements relating to disciplining children with disabilities. So that bulletin talks about the full range of protections, talks some about manifestation determination, but not quite in the detail that we just talked about it. But that talks about the requirement to provide services to students after 10 days of removal. So for example, if a student's been removed for more than 10 cumulative school days, more than 10 total school days, and there's another removal, and at the time of the removal, the school staff determined that this isn't a pattern, that student still must receive services during the period of removal. So there's information about that in that bulletin 06.02. The top bulletin there is 1402, and that is a bulletin specifically about manifestation determinations. So that's a resource that really, again, covers a lot of what we covered in the webinar, perhaps in a bit more detail. So if you've got additional questions, I would highly recommend going to that bulletin. And again, these are all available on our website. I love our website. There's a lot of wonderful stuff on there. Sometimes it's not easy to find. So if you can't find something, definitely feel free to contact us. We're here to help. And then finally, here is my contact information. You've got my phone number and my email address. If you have real specific questions, I guess I would say right now it's probably best to contact me via email if that's possible. It's a real busy time at the department right now, and I haven't been able to return phone calls as quickly as I'd like. So it's probably going to be easier for me to get back to you if you email me. But also, phone is certainly a possibility. It just may take a little bit. But that's my contact information. And final slide here is just saying thank you for your attention and your time. I really appreciate you taking the time to come and learn about this topic. Again, it's one that can really be tricky when it comes up. And I now would be very happy to take questions if there are any.
Great. Thanks, Marge. While we are waiting to see if any questions about any of the content you've presented come in, I just want to let everyone know I did get a message that the handout wasn't downloading, so I took it out of there and re-put it in, and you should be able to download the handout now. And just a reminder that you're going to want to either print or save that to your computer. Let's see, we have a hand up. Oh, it went down. If you, Chris, I see your hand up. I'm going to take your line off mute. I'm going to assume that you maybe want to ask a question verbally. So let me do that. Okay, Chris, your line is unmuted if you'd like to go ahead and ask your question. Chris, can you hear me? Okay. Maybe that was just a push button. So Chris, I'm going to remute your line. I'm assuming you don't want to ask a verbal question. If anyone else would like to ask something verbally, that is the cue. You will want to press the hand button next to your name, and that lets me know that you have a question and you'd like to ask it verbally, and I can unmute your line. Give me 1 sec, Marge.
No problem.
Okay, a question did come in. What exactly constitutes a change of placement?
It's a really, really, really good question. So I guess I would say in the context that we're talking about of discipline, that disciplinary change of placement, that's defined under the law as those two circumstances. So when a removal is for 10 or more consecutive school days or 10 cumulative when it constitutes a pattern. Now, so let's set that aside for a second. Change of placements in general, really placement is sort of a tricky concept in special ed law. So a student's placement is, is the location of where they're receiving services, whether that means what school they're attending, whether they're spending time in mostly general education settings or whether in some special education settings. It can be the services that are provided. It's kind of complicated and it's not simple. But basically, the way we kind of conceptualize changes of placement is anytime something that's going to change in an IEP, a student's IEP, is going to result in something pretty different for the student. So if they're going to be spending less time with their general education peers than they were prior, that's probably a change of placement. If they're going to be receiving significantly more or less services, so say a student was receiving 60 minutes of speech and language therapy a week, and for some reason they want to, the team feels that it's appropriate to reduce that to, say, a half hour or 15 minutes or something, it's really important. That would be a change of placement. It would be really important that the IEP team actually meet to have that discussion. Some types of changes to IEPs can be made without the IEP team meeting. That is only when the parent agrees to do so. If a parent says, no, I don't want to change that without a meeting, then the district needs to schedule an IEP team meeting. But for changes of placement, it's really, really important that the whole IEP team get together and meet. So that's tricky. I mean, again, I can't tell you exactly what is and what isn't a change of placement, but the way I kind of conceptualize it is if something is changing that's pretty big or is going to make a big difference for the student, particularly in the amount of time they're removed from their general education peers or a large location change, I'd consider that to be a change of placement, and I'd want the IEP team to meet to discuss it.
Great. And then a follow-up to that, someone wrote in, we are not saying that merely moving buildings or programs is a change of placement. That's a question.
Yeah, so this is a tricky one too. So it depends is going to be the answer, and it always drives people nuts because my DPI standard answer to things is it depends, but hopefully I can kind of give you some ideas of what it depends on. If a student, under IDEA it does say that changing a building, or like, so say if a program was in one school and then for some reason it's being moved to another school or things like that, those are not necessarily changes of placement if they're, basically able to be implemented the same way. In other words, it's the same amount of time that the student would be spending with their peers without disabilities, the services are the same. Those could be considered to not be changes of placement. There's also discussion in the law about the distance away from the student's home and all that kind of thing. It's all under least restrictive environment. And so, yes, it is possible that changing a building would not be a change of placement under IDEA. However, I always just encourage folks to proceed with caution and really think about what that's going to mean for a student on an individual level and just decide whether it would be important. So sometimes we hear of things like, schools are discontinuing one kind of program and starting another. We heard recently about a school district that I'm sure for, staffing reasons, who knows exactly what, but they were discontinuing one component of their early childhood program, and those students were going to be entering a 4K classroom. Well, that's a big change. I mean, that's a change of least restrictive environment. It's a change. So for those students in that circumstance, really that change couldn't be made without having IEP team meetings for those students. Under a different circumstance, it might be different. So it really does depend, but it is true that yes, if a building is changing because, a program's being moved or something like that, that may not be a change of placement under IDEA.
Great, thank you. Next question, what is the role of mental health diagnoses in determining manifestation if this is new information? So for example, if there's a newly disclosed trauma.
Yeah, that's a really, really excellent question, and I hope that, so basically I think what the role of that information is, there's huge implications for something like that when a team is making a manifestation determination. If a student, whenever anything is changing about a student, a new mental health diagnosis, now, maybe a different, like you said, an additional trauma that has come to light, those kind of things are exactly the kind of things that the team should be considering when making the manifestation determination. And that's kind of why I like to really highlight the fact that when we say caused by or a direct relationship to the student's disability, we're not just talking about labels. We're talking about disability in a much more global kind of comprehensive way for that student. So, you may have a student who a mental health diagnosis is entirely new for. Maybe the student had been diagnosed with a learning disability or something, and something changed, something happened, and now there's this new information that we need to consider. Well, if a behavior's occurred, it's really important that that information get considered, because it may be that, now this is part of the student's disability where maybe it wasn't before. Now, that might trigger other things, like if that were the case, the team might decide it's going to be important to do a new evaluation to make sure we've got all of the student's disability-related needs identified. But again, at least for the purposes of the manifestation determination, I'd say it's crucially important that that information get considered.
Great. Next question, when a district determines that 10 days constitutes a pattern, the district has 10 days to conduct a manifestation determination?
Yeah, so 10 school days, yep.
Okay. And then the follow-up is, does the student remain in his or her current placement or in the alternative placement until the manifestation determination? So, for example, if they have been suspended, do they remain there until the manifestation determination hearing?
Yeah, they could remain suspended, yes. You would want to make sure that, you know, once a student has served their suspension, and again, there's laws around how long suspensions can be. So again, that first resource that I talked to you about school discipline would be a great resource for that. But yeah, the student would be serving their suspension. Again, we're over 10 days, so it's really important that services are provided during that period of removal. Now, if for some reason the suspension, you know, again, I think there's a lot of ways that this could shake out in real life. If a student has a 3-day suspension, they serve that suspension, but the manifestation determination meeting can't be held until day 5. Well, on day 4, really, that student should be returning to the placement from which they were removed because they've served their suspension. So, you know, there's kind of, I don't know, again, it depends, a lot of circumstantial things can sort of play into this, but yeah, you can't like extend a student's suspension longer than you would if it were not a student with a disability, just to accommodate getting a manifestation determination in there. So, you know, timing is really important. I think oftentimes we see a manifestation determination happening when there's, you know, longer suspensions being contemplated or, you know, expulsions being contemplated for that reason. If a student serves their suspension, they need to be allowed to go back to school.
Okay. Next question. Do you have to hold an MD for every suspension after the cumulative 10 days has occurred?
The answer to that is yes. If they're the disciplinary changes of placement, yes, you do. So maybe a student is up for expulsion multiple times. It happens from time to time. You'd hope not very often, but it does happen. Then yes, the manifestation determine each time that there's a disciplinary change of placement being contemplated. If there are multiple suspensions and on each time the school staff determine it's a pattern, yes, you'd have to do a manifestation determination for each of those. So yes, if it's a disciplinary change of placement, the requirement for a manifestation determination is triggered. If it's not a pattern, so again, it's not that kind of contemplated to be more than 10 consecutive days, and the team determines that or the folks who are there at the time, the administrator and teacher, determine it is not a pattern, then that's not a disciplinary change of placement, and then no manifestation determination is required. However, services have to be provided if we've had 10 days of removal. So kind of separate requirements happening at the same time.
Okay. That takes care of all of the questions that we had in the queue that were kind of general in nature. I did, if we received a question that was very specific to, you know, someone's child or a particular situation, I did message you privately and just ask you to contact Marge after the presentation. I think just going to give it one more minute to see if anything else comes in here. Not seeing anything. So I think at this point we will adjourn our workshop for today and thank very sincerely Marge for her time and her expertise. Again, be on the lookout for that follow-up email with the evaluation and the recording of today's webinar. So thanks again, Marge, for a great presentation, and I hope everyone has a great rest of the day.
Thank you, Courtney. Everybody have a great day.
Thanks. Bye-bye.
Bye.